Hey friends, consumer attorney Rob Nahum here. As the courts begin to thaw out and reopen here in New York, I wanted to talk a little bit about what consumers can do in the face of the inevitable flood of debt collection cases that are gonna come. As the economy shut down, including debt collectors, the debt didn't shut down, just the debt collectors shut down, right? They couldn't file any new cases because the courts were closed. Process servers couldn't get out there and serve papers. And so there's all this pent up backlog, pent up demand that's going to come. Put that on top of the dramatic downturn in the economy and all these people out of work, we're going to see a huge deluge of probably record level debt collection lawsuits coming. So I wanted to just give 5 tips on what consumers being sued in debt collection cases can do to help manage that a little bit better. Number 1, do not ignore debt collectors. I know that there's this sort of innate idea that when the phone rings and the debt collection letters come, I'm just going to ignore them. I'm not going to pay attention to them. Not going to answer the letter. Not going to answer the phone. Debt collection is a process of escalation, right? It starts with in-house debt collection departments. So if you have a credit card with a bank, you're going to get phone calls or letters from the in-house debt collection department at the bank. And if they can't get you to pay, it's going to then go out to a collection agency, and then maybe the debt gets sold to a debt buyer, and then maybe the debt buyer hires lawyers, and then finally ends up in a lawsuit, right? So it's the series of escalations that's going to happen during the life of a debt. In each of those links in the chain there, if you ignore the debt collector, you're just pushing it further down that escalation, right? Well, we can't get in touch with the debtor, so we're going to give it to the debt collector, or we're going to give it to the debt collection lawyer, or we're going to file a lawsuit. So ignoring them doesn't make them go away, it just makes them escalated. Now, the real problem, particularly with debt collection lawsuits, is if you're in the habit of ignoring debt collectors, some of those communications that are coming to you from the debt collector may be court documents, right? It could be a summons to appear in court. It could be a copy of a lawsuit. Now, if you ignore those, the stakes are really high because the debt collector can go out and get a default judgment against you. The default judgment against you, the debt collector can garnish your wages, freeze your bank account, levy on your assets. Don't give the debt collector an undeserved win by defaulting. Don't ignore the debt collector. Communicate with them. If you can't afford to pay them, tell them that, right? If you've lost your job, tell them that. Communicating with the debt collector is really one of the most important things you can do to advocate for yourself and your debt. The second thing, if you have been sued by a debt collector, consider hiring a lawyer. 100% of the time in a debt collection lawsuit, the debt collector has a lawyer, right? 100% of the time. 100% of the time, you're going to be better off in that debt collection lawsuit if you also have a lawyer. Now, I understand that that doesn't mean you can afford a lawyer, and that doesn't mean that hiring a lawyer is always the economical thing to do. For example, let's say you've been sued for $1,000 and the debt collection lawyer is going to cost you $1,500. Why on earth would you hire the debt collection lawyer if you could just pay the debt collector and make the whole thing go away? So the economics does have to come into it, and you have to consider it. But if the stakes are high enough, if it's enough money at issue, and if you have the means to do it, you are going to be better off with a lawyer than without one. We debt collection lawyers, we know what we're doing. We know how to defend these cases. We know how to navigate. We know how to get you the best outcome that we can. The number 3 thing you can do is, if you are not going to hire a lawyer, you must at least answer the lawsuit, right? The way a lawsuit works is a document gets filed with the court. It's called a complaint. The complaint is the lawsuit. This is where the collection lawyers tell the court who it is you owe money to and why you owe that money. The responsive document to that is called an answer. The answer is the thing that tells the court, I'm here to defend myself. Don't give me a judgment by default because I have answered. Just taking that administrative step of filing the answer to the lawsuit cuts off the possibility for the moment that you're going to get a default judgment. That is an important step for you to take. So at a minimum, if you've been sued in a debt collection lawsuit, file an answer, okay? The number 4 tip for defending debt collection lawsuits is, if you've been sued, if you can't afford to hire a lawyer, if the economics don't make sense to hire a lawyer, consider hiring a lawyer for a limited scope engagement. Limited scope engagement. This is unbundled legal services. Basically, there are lawyers out there who will sell you the documents that you need to file in court. They will ghostwrite these documents, right? They don't become your lawyer in court, but they're making sure that you have the right forms to file with the court so that you're best positioned to defend yourself. Let me give you a for example. Statute of limitations defense. Let's say the debt collector sued you on a debt that's too old for them to have sued you, right? That's called the statute of limitations. The statute of limitations is an affirmative defense. What that means is if you don't state in your answer that the debt is barred by the statute of limitations, you've waived the right to that defense in court. So filing an answer is a very important thing to do, and filing it right is an important thing to do. The courts provide forms for self-represented people. I've seen these forms. In my opinion, the forms are terribly inadequate. They don't state all the defenses. You have to check a box. If you don't know that the statute of limitations is an issue, you may not know to check that box. So consider hiring a limited scope engagement attorney with unbundled legal services, where at least you know that the answer that you're going to be filing in court says all the right things and that you're preserving all your rights and defenses. Okay, finally, the fifth tip for defending a debt collection lawsuit is consider settling. Sometimes fighting is an important thing to do, but sometimes the practical thing to do is to just come to a settlement. Every debt collector I've come across has been willing to make a settlement. Now, whether or not that settlement is a good one for you, whether or not it's reasonable or not, that runs the whole spectrum. But you should at least consider reaching a settlement. Look, these debt collection cases can be beat. For example, like I said before, if the statute of limitations is expired, what's the reason to settle if you can beat them in court? But in other cases where you just don't have the defenses available to you and procedurally everything the debt collector's done right, you may want to consider settling. Okay? That's everything I have for you. Please take care of each other. Love and light.